case briefs, and so much more. LSData's got what you're looking for.
In the United States Tax Court in 1999, the case of Ames v. Commissioner unfolded, revolving around the thorny issues of taxation related to an individual's illegal espionage activities. Introducing suspicions of high-stakes government secrecy and underhand activities, this notable case pivoted on the claim from the taxpayer that they had not directly received income from such illicit actions, thus calling into question the government's right to tax them and enforce accuracy-related civil penalties according to Section 6662A. The taxpayer in question, a former operative for the Central Intelligence Agency, CIA, faced accusations of income from covert espionage operations, forcing the court to thoroughly manipulate the foggy arena of classified governmental operations. Spanning over the course of 4 years from 1989 to 1992, the taxpayer, jointly with his spouse, filed tax returns reflecting primarily his CIA income. As part of his duties, the taxpayer initiated contact with Soviet officials in 1984, which prompted a thorough examination of the income source during these years of service. Piercing through this shroud of espionage and secrets, the court made its ruling clear, centering their judgment on the contentious Section 6662A penalties. The taxpayer was found liable for the negligence penalty in each of the taxable years under scrutiny. Controversially, the court declared that the Double Jeopardy Clause of the Fifth Amendment did not provide the taxpayer with constitutional protection from these penalty assessments, rejecting the petitioner's plea to produce the government's criminal reference letter under the work product doctrine. The case was a landmark in the usage of the Hudson approach, used to analyze whether a law was intended as a punitive measure or to safeguard the government's revenue. This significant case culminated in favor of the ruling party, with the court emphasizing that these civil penalties for tax liability were not punishment, but rather remedial measures to protect government revenue, recover expenses and losses incurred through the taxpayer's actions. Such unconventional espionage-related income, the court implies, does not allow for an exception from the weight of the law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.